Welcome everyone to our webinar on shielding your business, ensuring NDIS service agreements protects your business. My name is Astrid and I am a senior lawyer in LegalVision's commercial and regulatory team. I'm joined today by my colleague Stephanie, who is also a lawyer in my team. Before we begin, a couple of quick housekeeping items. You'll receive both the recording and the slides in your email. You can also submit your questions in the chat box and we'll answer them at the end. We also ask that you please complete the feedback survey at the end of the webinar. Also, all the attendees are eligible to receive a free consultation with us to discuss how we can help you with your contracts or any of your legal needs, whether it's NDIS related or not. To request your free consultation, provide us with your contact details in the survey that appears at the end of the webinar. So today we will be discussing very briefly a summary of the NDIS. Then we'll go into depth into why a service agreement is required. We'll take you through some key terms. We'll focus on cancellation and termination clauses, variation and regulatory changes, disputes and difficulties that arise, and general compliance with other laws, not just the NDIS Act. And we'll finish with a question and answer session. Those questions can be submitted through the webinar for the chat function, and we will go through them. And now Stephanie will get us started with the key elements of our webinar.
Thanks, Astrid. Well, welcome everyone. As you would be aware, the NDIS is a scheme established by the government to assist members of society who have significant disabilities by providing access to funding. Now, participants can be funded for a range of services, and the regulations that are applicable to you as a provider of those services will vary depending on the type of service you provide to participants. The NDIS pricing arrangement and price limits, which I'll refer to as the price guide throughout this webinar, sets out the categories of services, the maximum price limits, and some conditions for claiming for certain services. Registered providers need to comply with the NDIS price guide, and all providers, regardless of registration, will need to comply with the NDIS Code of Conduct. Now, supports fall into a number of categories aligned with their purpose and set out in line items in the price guide, which is updated every year. Providing services under the NDIS in accordance with the price guide and all relevant laws and regulations is best managed through a service agreement. However, this is not always mandated by law, and Astrid will now touch on when this is and is not the case.
So we'll go now through when you'll need a service agreement. Basically, a service agreement is a contract which sets out the obligations and rights of all the parties involved. Generally speaking, there is no legal requirement under the NDIS legislation for you to have a written service agreement unless you're providing specialist disability accommodation. However, note that the ATO states on their website that a written agreement is necessary for you to be able to claim the GST-free threshold for the supply of services to NDIS participants. A service agreement also helps create clarity around the scope of your services, what the participants can expect from you and your staff, and what you can expect from the participant. This can help to minimize disputes as both parties are aware of their rights and obligations. The written agreement can also assist with showing your compliance with all the applicable regulations, including the NDIS Code of Conduct, but also the Australian Consumer Law. Registered providers are required to keep appropriate and accurate records, including records of services delivered to participants. A well-drafted service agreement, including a schedule of rates and services, allows you to list out the type of services you're providing to participants. Moreover, certain expenses and items in the price guide, for example, claiming for transport or cancellation, can only be done if you've obtained the participant's consent in advance. The service agreement allows you to obtain the consent and also provide written proof in the event of a dispute. Similarly, if you're offering under capacity buildings programs of support, you will need specific terms and conditions setting out the details of the programs on offer. Programs of support are a way of delivering capacity building therapy in a group setting. The price guide sets out that the provider must enter into an agreement with the participants for each program of support. Although it is not stated that such agreement should be in writing, a written agreement would ensure that you meet your obligations and that there is no confusion. This can be done either with standalone terms and conditions for each program or it could be annexed to your service agreement. We also strongly recommend that supported independent living arrangements are reflected in a service agreement, as SIL arrangements are now being closely scrutinized by the NDIS. This is especially important if the same provider is offering the SIL house with the SIL services or offering SDA and SIL. Just as in a nutshell, we basically recommend that at all times, all service providers have a service agreement in place, and that the agreement is entered into prior to starting to deliver the services. Steph will now touch on what should be included in a service agreement.
Thanks, Astrid. Well, like all contracts, a services agreement should outline some key terms. And in the NDIS space, some of these considerations will be the parties signing the contract. So frequently, the participant may not have legal capacity to sign a services agreement, and the contract would need to identify the person signing on behalf of the participant. It will also need to consider the services that will be provided to the participant and how much those services will cost, as well as whether the price charged has any additional fees that need to be applied, such as cancellation fees and transport costs. You'll also need to acknowledge whether you will subcontract your services. And more generally, the services agreement will outline your obligations as well as the participant's obligations. Now, your participants' obligations will mainly be the obligation to pay, so you must set out how and when you expect them to pay. Your obligations will be considerably more broad, including the following: specifying any inclusions and exclusions to your services, your approach to privacy and confidentiality, and who will be responsible for and liable for any faults with your services, and to what extent. Now, a service agreement also allows you to set out other key details, including the type of plan management that your participant has, a list of key contacts, such as support coordinators, authorised representatives, or parents and guardian details where necessary. It's also essential to outline who is responsible for the participant's obligations. If you provide services to children or to a participant with reduced capacity, you will need to consider who is legally able to sign a services agreement. Guardianship and custody orders may also be in place for children, so consider how you will process these requirements and ensure you have information about who will be signing the services agreement and whether they have the authority to do so. Now, when describing your services, you'll want to be clear about what you provide. You have an obligation to your staff under work health and safety regulations that they are able to provide the supports and services in a safe and competent manner with care and with skill. To make sure that you can comply with this, you'll need to be clear with participants about the services that your staff are qualified to provide. You will also want to specify your exact rates and if they vary depending on days or times. Some participants may not be aware of different rates for weekends or out of usual business hours. So ensuring that there's clarity about your availability and the prices for your services can help reduce the risk of potential issues around payment for services and any disputes about what it is that you have promised. It's also useful to specify whether you will bill additional fees for note-taking, report writing, and communicating with other providers. We often see disputes arising with support coordinators if the participant was not aware that the provider was charging for phone calls and emails. Now, some other general key considerations are the length of the contract, the extent to which any party can change the scope of the contract, and the dispute resolution process. As a final point on this, it is essential that you write your NDIS appropriate services agreement in plain English. Anyone should find it easy to read and understand the key points. The document must be a good balance between protecting your business and its legal interests, and also between making the document fair to vulnerable participants. Now, Astrid is going to touch on how supports and services may be terminated or varied.
Thanks, Steph. The reason we're focusing on cancellations is we see a lot of disputes between providers and participants about the charging of cancellation charges. They are important to include because you are likely engaging employees and contractors to assist you with providing your services. You will also have an obligation under the award or under the contract of contractors to pay your staff if the shift is cancelled by a participant. You also, in some cases, your workers may fall ill or be unable to attend a booking with a participant, and you are the one who will need to cancel. In this case, you have to weigh up your duty of care to the participant and whether you have to provide a replacement staff member. And participants may also need to cancel their supports, either for the one appointment or they may want to cancel for a few months or weeks if they're going on holidays. The price guide sets out the guidelines in relation to short notice cancellations. Basically, a cancellation is short notice when the participant either gives less than 7 clear days notice or basically does not attend. If the participant submits a short notice cancellation, the provider is eligible to claim up to 100% of the agreed upon cost of service, subject to the NDIS price guide and whether the line item is identified as being able to claim a short notice cancellation. It is a business decision whether you would like to state in your service agreement that participants are required to give you 7 days notice of a cancellation. You can decide to put less, 3 days, 4 days, 48 hours is usually what we say, but you cannot change it to more than 7 days. Now, what happens when you need to cancel? The same rules do not apply to your cancellation in that you cannot charge a cancellation fee if you have cancelled the shift. However, your service agreement should set out the procedure if you need to cancel a book shift. You may have the duty of care, as I've just mentioned, to participants who have high needs and are at high risk to provide an alternative staff member. If you're not able to do so, or you do not have the staff and you are aware that you do not have the staff, this should be stated in your service agreement, that if shifts are cancelled, you will not be providing an alternative staff member. On the flip side, if you know you have a high needs participant, this can be flagged in the service agreement that you will use best endeavours to replace the staff member upon a short notice cancellation. Your service agreement should also request that participants should let you know if their needs changes or if they are high risk of harm if a shift is cancelled. Steph will now touch on the need for variations and changes in your service agreement.
Thanks, Astrid. Well, as you probably know, the NDIS is an ever-changing and developing space. Given that it's only been 10 years since the Act came out and the scheme has been in place, there are always changes in the space as issues arise and then get ironed out. Participants are also not guaranteed funding, and the amount and type of funding that they receive may change with every plan review. The price guide is also updated regularly. So a services agreement in light of this should be drafted in such a way that it's flexible enough to incorporate certain changes without the need for a formal variation. It should also have a built-in mechanism allowing for formal variations as well, and incorporation of larger changes. A robust change process is required to ensure that you can comply with changes from the regulator or changes in any law. You must also ensure that the change process is fair to both parties and that you're providing adequate notice of any changes to your customers. You can also request that participants provide you with notice if there are any changes to their funded supports or formal supports, such as support coordinators or plan managers. Now, the best way to achieve this is through acknowledging the notice periods and including a variations clause in your services agreement. But you should also consider in your general business management how you set things up to be able to respond to change. Astrid's now going to speak about the challenges that may face service providers, including if or when disputes arise.
Disputes can arise between yourself and your subcontractors and staff, as well as with participants. We're focusing mainly on the disputes with the participants at this stage, and we will be presenting a webinar later this year about disputes with subcontractors/employees. Participants who are worried about the quality or safety of the supports or services they are receiving can make a complaint to the NDIS Quality and Safeguards Commission. If you or your staff are regulated by the Australian Health Practitioner Regulatory Authority, AHPRA, complaints can also be made to AHPRA. Privacy complaints can be made to the Privacy Commissioner, and in certain circumstances, complaints about services can also be made to the applicable Customer Affairs regulatory body. This is particularly relevant if you're providing accommodation services. How do you manage complaints? The management of a complaint will often indicate whether this will be escalated to a regulatory body or not. It is important to have an internal complaints handling process to ensure that the participants have the chance to approach you first and resolve any issues before escalating matters. Being heard and being able to voice a grievance can often stop a complaint from being escalated. What we see frequently in our practice are complaints that arise in relation to the pricing and the delivery of the services. This invoices being disputed, as we said before, cancellations, and also the type of services, especially in terms of accommodation and short-term accommodation, are where we see the most complaints. We also see a number of complaints relating to privacy and confidentiality. As a provider, you often handle a great deal of personal and sensitive information about participants. If this information is not handled in accordance with the Privacy Act, the Office of the Australian Information Commissioner, or the OA, will step in to resolve misuse and complaints. Some of those misuse can be unintentional if you have a cyber breach, or it could be intentional if you've called a support coordinator or if you've spoken to someone without the consent of the participant. You would need to ensure that your internal practices are compliant with the Privacy Act and that you have all the documentation such as privacy policy, privacy collection notice, and where relevant, that you have obtained the participant's informed consent or that of their representative prior to collecting and using sensitive information. You also need to ensure that you comply with all data retention laws. What about the disputes that you may have with participants? The one that we see the most are non-payment. Non-payment of invoices is often a very big challenge for providers. It is difficult to enforce payment against participants who may not have any assets or very little income. Because collection or recovery of debt can be quite difficult, we recommend making sure that you take steps to protect yourself. This can be taking out debtor insurance, enforcing payment on a frequent basis rather than letting debts build up, and opening clear communication of the participants and, where relevant, plan managers and support coordinators about the type of funding and the amount of funding that the participant has. We also see a number of disputes in SIL housing where there is damage to the property. We do have a leasing team that deals with these matters, and we can provide advice on how to handle disputes and property damage, and in some cases, eviction of participants. Steph will now conclude by discussing the importance of compliance with a number of other laws.
Thanks, Astrid. So a couple of considerations in terms of our general compliance across the board. Now, as we stated, the NDIS Code of Conduct is quite pivotal and sets out your obligations regarding service provision. So it's absolutely essential to familiarise yourself with the code and ensure that you provide your services in accordance with it and all applicable NDIS regulations. Another consideration to think about is the unfair contract terms regime. In take it or leave it contracts for the supply of goods and services to individuals, which is what a form of services agreement will be, if you include what is considered an unfair contract term in your service agreement, the term will be considered void and you may be subject to significant fines, which for some businesses may be in the order of up to $50 million. And this regime takes force in November of this year. Now, a term is considered unfair if it would cause a significant imbalance in the parties' rights and obligations, if that term is not reasonably necessary to protect your legitimate business interests, and if it would cause detriment to the other party if it were enforced. Now, of course, whether a term is unfair needs to be evaluated on a case-by-case basis in your services agreements, and it's something that we discuss with our clients quite often. But some general examples to avoid are requiring immediate payment for support services, terms that issue an automatic renewal of the contract, such as where your engagement with a participant automatically renews for 12-month periods with little chance for the participant to provide notice to cancel. It may also be considered unfair if you require clients to indemnify you for damages caused during the provision of your services. And if you try to obtain blanket waivers for your liability in certain circumstances. Now, this can be particularly problematic where specific states ban them in relation to service provision for minors, and they are typically quite difficult to enforce. Now, you'll also need to ensure that you're aware of your privacy obligations relating to the collection, use, and disclosure of personal and sensitive information, as Astrid has touched on. Another thing to consider is being aware of taking pictures and using them for advertising. Now, media consent forms are easy to obtain, and we very frequently draft them for our clients, just to ensure that you have proper consent to use photos and videos from your participants as part of your marketing or your ongoing brand awareness. A key consideration is always having regard to your participants themselves. Now, the participants accessing your services are in a vulnerable position, and all of your legal documentation and processes should be formed to prioritise their safety, as well as take the necessary steps to protect yourself. You will want to ensure that your approach to service provision champions agency, choice and control, and informed consent. Now, you'll also have obligations with regard to your staff and contractors, which Astrid has made mention of, and we plan to go into further detail on in a webinar later this year. Now, as part of your providing your services, you will likely have several staff or independent contractors. Not only do you have all of your usual employment and WHS obligations for your direct staff, there are several taxation considerations when engaging contractors, including the possibility for paying superannuation. And these considerations will also change where you are registered and use unregistered providers. As mentioned, these considerations are quite specific, and we plan to go into more detail in future. And just generally, watch this space. The NDIS is currently undergoing review as of October 2022. We are actively watching that review and will adapt our resources and work based on the latest information. As things change regularly, you'll want to make sure that you keep abreast of the changes and that your services agreements reflect any developments. And we play a pretty key role in assisting our clients with keeping on top of those changes. So, that concludes the main part of our webinar. You might find our publication useful, which is our NDIS Service Agreement Fact Sheet, which summarises a lot of what we've discussed today. And you can download that from the handout panel or by scanning the QR code that's on the slide currently. And we also have an upcoming event that may be of interest to you, which is using the ACLA to bring overseas talent to your aged care or healthcare business. Now, this is taking place on Thursday, the 28th of September at 11 a.m. We would love to see you there. I think there's going to be some really good information to be shared there and a good chance to ask some more questions. Speaking of questions, we're going to be answering yours shortly. While you take a moment to submit them, I will take a minute to tell you about our membership. Now, LegalVision's membership is a cost-effective alternative to the expensive hourly rates you may have experienced with other law firms. For an affordable monthly fee, you receive cost certainty and all-inclusive legal services, including unlimited document review, including drafting, amending, and reviewing business contracts, including your services agreement, and commercial leases. It also includes unlimited advice consultations with our team of 100 specialist lawyers, including business structuring, employment, disputes, and more, including the regulatory work that Astrid and I frequently undertake. And it also includes unlimited domestic trademark registration. As a LegalVision member, you won't worry about the costs of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all of the business as usual legal work so that you can just focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how our membership can help you, you can request a free consultation when the survey appears at the end of this webinar. And now we'll take a moment to answer some of your questions. Astrid, what do we got?
So the first question I've got is, do we need separate service agreements if we provide different types of services? Generally, no, unless you're providing accommodation. We do really recommend that you pull out the accommodation services, whether out of the area of your general terms and conditions. If you're also providing support, coordination, and plan management, as well as some other different type of service, we do recommend, due to the conflict of interest, that you have separate agreements for support coordination, which would include a conflict of interest declaration as well. Is it enough to have written consent provided via email for a service agreement, e.g. a reply to an email stating I agree to the service agreement terms and conditions, or do we need a signature each time? This can vary depending on your state that you're in and also what is in the service agreement. We provide in our service agreements that it can be accepted by email. So when we set it out, and if you have a clause in there saying it can be accepted, and you can even put in a general clause saying that the service agreement can be accepted by asking you to start providing the services. So this is something that we would be addressing when we do draft your agreements. Do we need to arrange a new service agreement when the participant receives a new NDIS plan, or can we roll over the existing service agreement? You can certainly roll it over, but it will again depend on what is in your existing service agreement. If there is an extension clause, or usually by mutual agreement, then you can just roll over the agreement as you need to. I am interested in becoming an NDIS provider using my lived experience, combined with coaching and consulting skills. Can you advise how to start offering services? There are a couple of different ways, and this is where our corporate team would get involved. You can apply for an ABN and start providing services as an independent contractor. It can take 12 to 18 months to become registered, but you do not have to be registered to provide services. You can also form a company and start providing services via a company. There are pros and cons from both sides, and we can certainly talk to you about this more if you want to get a free consultation with us. We have one more question about what happens when there is a plan manager involved. This is a slightly more complex question, and more than happy to talk to anyone about this in our consult. But generally speaking, if a plan manager is involved, it doesn't change the contract between you and the participant. The participant is the person who has signed the contract and who has taken the obligation to pay. We would build in some clauses in your contract about authorizing the invoices, but if there is a dispute between yourself and the plan manager, this would usually sit outside the contract. I think we've reached, yes, we do have a fact sheet on the unfair contracts points mentioned, which we can be found just like on our website.
And happy to discuss any of that in a free consultation as well. It's an interesting area, given that unfair contract terms, we have to identify where they're covering a legitimate business interest, and there are sometimes reasons to place an onerous obligation on a participant, but we have to balance that against what the regime itself does. So yep, absolutely have our fact sheets available, and would love to discuss it with you in more detail over a consultation. So yeah, feel free to book in. Just seeing if there's any final questions coming through.
I think there is one. Someone is asking about waivers for minors and issues with minors. It's quite a complex area, and again, we're happy to discuss it with you, but the issues you often have with minors are with divorced and separated parents, about who can organize the services, who can access the information, and if you're providing capacity building, who has access to the file. There are also other issues depending on the states. Some providers who are providing STA or community access understandably do not want to be liable for anything that happens if they have a minor, especially someone that has complex behaviors. However, in some states, it is illegal to have any sort of waiver in terms of minors. So this is we would need to address that with you on a case-by-case basis, depending on where you are located. But there are ways to minimize your risk, and we're happy to talk to you about those. What are the steps you need to take when a participant wants to change providers? This also depends on the type of services you would be providing. For example, if the participant is in a SIL house or an SDA, or if they're just changing for social and community participation. Generally speaking, there would be a handover, but the participant would have to agree to the handover. You should have some internal process that you had to follow in terms of how you would terminate the agreement, what you would do with the information that you have, and how long you would retain the information, and what you provide to another service provider. something again similar, what paperwork is required to change. Usually we would say you would need an informed consent to be able to speak to the other provider, but though it is not strictly necessary, someone can just terminate and sign on with you. In terms, you may want to check the funding, and if they have a support coordinator or plan manager, you can also request consent to speak to the plan manager or support coordinator to make sure they have the required funding to pay for your services.
Yeah, absolutely. So there's a question that's just come through about the automatic renewal of contracts and regarding the unfair contract terms regime coming to effect in November of this year. So regarding automatic renewal terms, they can be quite useful from a service provider perspective, because you'll likely have many, many clients coming on board and you don't want to always have to issue communications to different participants regarding their service agreements. However, the reason that things like this get flagged in the unfair contract terms regime is if we require participants to provide notice well in advance of when the renewal is coming into effect. Let's say that you ask them to renew in December of the year, but you need them to provide notice 60 days beforehand. That's quite a long lead time, and people tend to forget about these sorts of things, and it may just slip through the cracks. So if that happens and there's a long notice period lead time, and then that contract renews for a further 12 months and they're kind of locked in with you or not able to terminate, that is when a clause starts to tilt towards being considered unfair. So automatic renewals are definitely something that can be incorporated where it's legitimate for the business interests, and also where it's balanced against having a reasonable notice period and reasonable termination rights and how long it actually renews for. So that's just a couple of considerations that we look at when drafting a service agreement and thinking whether it's reasonable to include an automatic renewal. Astrid, anything you want to add on that?
Yeah, in terms of renewal, if you have a clause in your service agreement that says that at the end of the contract that it will just automatically keep going until such time as you terminate, then it just means that you could just keep providing the services and just have a termination clause of usually 2 weeks notice, and the contract can be exited and they're not locked into a contract. So there are ways that we can build in both a renewal and a termination to make sure that your contract is fair and balanced.
Absolutely.
For automatic renewals, do we need to send a service agreement with updated funding for each plan? It depends. It also depends on what type of services you're providing and also the value of the funding. If you're providing for a high value contracts, for example, if you're providing SIL, it would probably be best to obtain a new, or at least a new funding amount, not necessarily a new service agreement. Which is where what Steph was talking about earlier about the importance of variation clauses in your agreement. So the agreement would be varied for the amount in the new SIL agreement. If you're providing services for social and community participation, or if you're doing capacity building, speech therapy, occupational therapy, and you're charging by the hour, it is less important because it is pay as you go. Alternatively, if you're dealing with NDIA managed clients, it is slightly different if you're dealing with a self-managed client. Those are things that we do work with each provider on a case-by-case basis as questions arise.
Got a little bit more time for any final questions, if anything leaps to mind. Anything that doesn't, we're happy to discuss in a consultation following on if anything else comes to mind. I often find as soon as I leave a meeting, something comes to mind. So yeah, happy to be reached out to following this as well.
It is also a good idea to run your service agreements by your insurers, because some insurance providers do have specific clauses that they may or may not want included in your service agreement.
Great point.
There's one more question coming through.
Oh, awesome.
Can you subcontract the services? Generally speaking, yes. There would be a number of considerations for the use of subcontractors and whether they are companies or sole traders, and there could be payroll implications, superannuation implications. This is where we could arrange a consult with our taxation team if you would be interested in learning more about the use of subcontractors. A lot of providers do use subcontractors, especially when it comes to short notice cancellations of their own staff and they have to fill shifts, but they do not have the required employees. happens when your participant has escalated behavioural issues and one staff member is not enough? Is it an increased risk to staff and participants? Yes, definitely. You have a duty of care to the participant, but you also have a duty of care to your staff. If you're in a situation where the participant requires 2-to-1 support, there are a few ways you can go about it. Obviously, the first thing to check is if there's enough funding to provide 2-to-1. If not, if there's a PBS in place, a positive behaviour support plan. The other option, if there isn't enough funding, is to ask the participant to put in for a change of circumstance or an S48 review. Whether you can stop providing services and pull out your staff would be on a case-by-case basis. You may be very well within your grounds to state, our staff isn't safe, we have OHS obligations, we cannot send a staff member due to the escalated behaviours of the participant, and require that informal supports are present until such time as the participant has more funding. You can also request that more funding is provided or used up more quickly until such time as a review is happening in the background. But again, it is there is no straight answer because there would be so many different scenarios that could arise. But generally speaking, you would be conflicted between two different duties of care. I think this about wraps it up for today. After the webinar ends, a survey will pop up. We would really appreciate if you could complete the 30-second survey. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you, generally speaking, with your NDIS questions, or if you have aged care questions or anything relevant, corporate, commercial law, we're more than happy to help. That's it.
Thanks so much for joining us, everyone.
Thank you for your time.
Thank you. Bye.